Okay, so transfer of property act. Next type of alienation that we have is on mortgage. Okay, so mortgage is again another type of alienation which is given under Chapter 4 of the Transfer of Property Act. If you look at the sections, right, a lot of sections are there talking about different types of mortgage, rights and obligations, then few other provisions here and there like marshalling and all that stuff. Okay, now all of these sections are not important. What is important, we will be discussing that part from these 58 to 104. Few sections are relevant and few sections are important. So we will be discussing that. Okay, main important provisions are like different types of mortgage, rights and obligations, marshalling. Those are what we need to study here. All right, so what is mortgage? Jishnu?
Collateral given to borrow money.
Yes, right. So mortgage, again, like same thing we can do for movable properties also, right? Like in case it's a movable property, we say it's mortgage, but if bond. Yeah, bond
No,
also.
in case of movable property, it's called pawning, right?
Yeah,
something like
pledge contract is right. Pawner and pawnee, like the parties are called, and the contract as such is called as pledge, and it's part of Indian Contract Act again. So mortgage, when we talk about mortgage, it's always some sort of immovable property. So it's kind of a security which is given by the borrower for repayment of the loan to the lender. It's as a security that the person is giving, that in case I'm not returning or I'm not able to return the money also, it's fine, you at least have something to compensate for that. So object of mortgage is definitely to secure the debt or any other obligation that the person is having. It will protect the interest of the lender, and he will also have the surety, right? Fine, in case there is some problem also, I have an alternate way to get the money or to recover it. So for mortgage, again, it's type of a security that is given to the person. And mortgage as such, the word is being defined under Section 58 of the Transfer of Property Act. Okay, so if you have the Bare Act, you can open that as well. Section 58 provides for definition of mortgage. It also tells us about different parties who are involved in a mortgage. Okay, let me share the screen rather, you will be able to see. Yeah, so mortgage is defined under Section 58 of the Transfer of Property Act, and there we have like sub clauses. Okay, there only different types are also defined, plus what is mortgage in general is being defined, and after that we have different types of mortgage also in the same section. So what is mortgage? It is again transfer of an interest in specific immovable property. Now, a person might be having 2-3 immovable properties. There it's very important that he specifies that for this immovable property only I'm transferring interest, not for all of the other properties which I have. Or it might be that in this entire 3-story building, only for 1 floor I'm giving it on mortgage. So it has to be some specific immovable property which the person will specify in the mortgage deed itself, so that it can be identified at a later stage in case there is a situation where the person needs to sell the property and recover the money. For the purpose of securing payment of money advanced or in advance or to be advanced by way of loan, an existing or a future debt or performance of an engagement which may give rise to pecuniary liability. So it would include a lot of different things. Transfer of an interest. I am transferring my interest on the property to another person, and it has to be a specific immovable property only that can be easily identified from the mortgage deed which will be prepared. and it is to get an amount from a person with a security. The other person will also be assured that he will return the money. In case he is not able also, I at least have something not to worry about it. Now from this definition, we get three essentials of mortgage. First one being transfer of an interest, specific immovable property, securing the payment of money advanced. So first one is there must be transfer of interest. So person is transferring interest only for the purpose of getting an amount of loan. There is no transfer of ownership as such. Like for most of the different types of mortgage, there is no transfer of ownership as such, but it is only transfer of interest. Some rights are being given. It may be that for a specified duration, you can enjoy this property. You can have possession of this property, but then you cannot sell it. You cannot give it to another person on lease. There will be some other restrictions, as it's not ownership that is given to the person, but it might be simply possession or a right to enjoy the property. So that is the first thing which we have, transfer of interest, and it will be clearly defined in the mortgage deed what all interests are being transferred, what all this person can do, what are his rights and obligations. The right of mortgagee is only an accessory right which is intended merely to secure payment of the lend. Mortgage is simply a transfer of interest in immovable property while ownership will still remain with the mortgager. So the parties involved are mortgager and mortgagee. Mortgager is the owner of property who is transferring the property to another person, and mortgagee is the person who is giving the amount of loan. So when mortgager is transferring his interest on the property, mortgager or the owner of property, when he is transferring his interest on the property, he will still remain owner of that property. His ownership is not gone, but simply he has transferred some interest. Like maybe he can tell the mortgagee that you can reside in this property until and unless I return the amount. Or sometimes it may be that you can enjoy this property, you can take benefits out of this property unless and until you have exhausted that much of benefit. Like if you had given me 3 lakhs, that amount you must have, that much of benefit you must take from the property. So unless and until you have taken enough of benefit, you can retain the possession. You can use it for that duration. Okay, so there is only transfer of interest, but as such, owner still the mortgager only will be the owner. In most of the more different types of mortgage, owner will still remain the owner. Ownership is not transferred. Secondly, specific immovable property. It's very important that property is clearly identified in the mortgage deed, because in case there is a situation when person is not able to repay the loan, right? The mortgager is not able to repay the loan and mortgagee wants to recover money from this mortgaged property. So there it becomes very important that it's clearly specified in the mortgage deed and it can be identified also, and from there he can recover this amount. So one person having 3 plots of land, he needs to specify the plot he is giving on mortgage. It's very important that it has to be clearly identified, otherwise it's not like 3 properties only he will be getting. Last one is securing payment of money advance. So transfer of property is mainly for the purpose of getting an amount of loan. Otherwise, a person might not be willing to give that amount without any sort of security, as there will be no assurance whether he will get back the amount or not. So it's very important that some kind of security is there and person is able to give the amount without worrying too much about whether it will be returned or not. Right? So these are like the essentials which we have in case of a mortgage entered into between parties. So there are basically 3 different words that we get in mortgage. And these words are also mentioned in section 58 clause A. It is the instrument, the money involved, and the parties who are there. The instrument, which will specify rights and obligations of parties, the type of mortgage that it is, duration, everything. That instrument is mortgage deed, where everything will be mentioned. Money involved, whatever is the amount concerned, that is the mortgage money, how much amount the person has taken. And there are two parties involved in a mortgage, that is mortgager and mortgagee. Mortgager is the transferor who is transferring his property to another. That means he is owner of the property. And mortgagee is transferee, to whom property is being transferred, or he is the money lender who is giving the amount in return of that or in exchange of that. Okay, so in case of mortgage, there are two parties, mortgager and mortgagee. Mortgager is transferor, mortgagee is transferee. And these three words, again, we get the definition under section 58 itself. All right. This part is clear, right?
Yes, ma'am.
So this second part basically provides for the definition of all these different words. Now, mortgager or mortgagee, also we have seen who is a mortgager and who is a mortgagee. Now, who is mortgager? Mortgager is the person who is taking loan in exchange of transferring interest on his specific immovable property. And mortgagee is the person who provides the loan, and in return he is taking some interest, possession, or other rights over an immovable property. Mortgager gives collateral, asset, or interest, and mortgagee will receive it. When he is taking money, some interest on a specific immovable property will be transferred by the mortgager, and same thing mortgagee will be taking in return of it. Mortgager has to give ownership of the property until he or she pays the principal sum or interest. There may be certain mortgagee retains ownership of property under the mortgage until payment is made in full. It has to be possession, okay? Just read it as possession. So mortgager will be transferring his possession to the other person. In some cases, there will be ownership also. We'll discuss those different things. So it can be that he is giving ownership or possession of the property, and it will be there with the mortgagee until and unless he is able to return or repay the amount. Once he is able to return the amount within the given duration, he can ask for a return of the property. So mortgager will give his interest, the ownership, possession, whatever, to the mortgagee until and unless he is able to return the amount. And in the same situation, mortgagee will retain that ownership, possession, or interest until and unless full amount is made to him, until and unless this loan is cleared from the part of the owner of immovable property. Mortgager must accept mortgagee's decision in case of default to clear the loan. Mortgagee has the right to sell the property if mortgager defaults in payment. So if mortgagee wants, mortgagee can retain the property. He can sell it to someone and recover the amount. Whatever it is, mortgager will have to accept it, because he fails to return the amount within that agreed duration of time. He could not return it, so he will have to accept.
Ma'am, but the mortgagee is not having the ownership right. So how will we be able to transfer the property to someone?
Because he will be, in some cases, he will have ownership rights. In other cases also, right? Even though ownership right is not there, it's clearly mentioned that, like right now, at present, you don't have ownership rights. But if this person fails to return the amount within maybe 1 year, 2 years, after that you get a right, because otherwise it's of no use, right? What will you do with that interest, simple interest or possession? So that clause also will be mentioned, that if I'm not able to pay the money within 2 years, then you get a right to recover it from this thing. Might be most of the cases you will have property documents with you. Okay, you either have property documents or you will have the property only might be given to you completely, or maybe some declaration is given that in case I'm not able from this property, you can recover this amount. So based on that declaration or the documents or whatever they have, they can proceed with it. Okay.
Okay, ma'am.
Actually, there are too many different types. Yeah, these are the different types we have, and situation will vary from case to case. Okay, so section 58 clause A, it provides for definition of mortgage, different parties involved, the amount involved, plus parties amount, as well as it also talks about the instrument. Instrument is mortgage debt. Yeah. So all those definitions are being given. After that, same section in different clauses, it provides for 6 different types of mortgage which are applicable. Okay, so first one being simple mortgage, section 58 clause B. Second is mortgage by conditional sale, section 58 clause C. Usufructuary mortgage 58 clause D. English mortgage 58E. Mortgage by deposit of title deeds 58F, and anomalous mortgage 58G. So these are 6 different types of mortgage which are mentioned under Transfer of Property Act itself, in that same section defining what mortgage is. Now, what are these different types of mortgage that we have? First one is simple mortgage, defined under section 58 clause B. So simple mortgage is where the mortgager as in the owner of property. Mortgager does not deliver possession of mortgaged property. So yes, he is taking loan, he is having an immovable property, but he will not deliver possession of the mortgaged property. He will not transfer possession of the property to another person while taking the loan. But what will he do? He gives a person undertaking to the person undertaking to the mortgage, to the mortgage, that he will repay the amount due under mortgage. That means he is not handing over possession as such, but he will simply give an undertaking that in case I fail to repay the amount, then I will, like, you will have the right to recover it from this property. So he's simply giving an undertaking to the mortgagee that he will be returning the amount which is due under the mortgage. So here, in case of simple mortgage, the mortgager or owner of the property impliedly or expressly agrees that in case of failure to repay the amount, mortgagee will have a right to sell it, or mortgagee can recover it from this property. Okay, or in case of mortgage money, mortgage property in payment of mortgage money. So whether impliedly he has said that this is the property, if I'm not able to return the amount within this duration, you can sell this property and you can recover the amount. That is simple mortgage, where we are simply having a declaration made by a person. As such, there is no delivery of possession, or there is no transfer of ownership or transfer of title deeds or anything. Simply a statement that is being made by a person, a declaration that I will be returning the amount. In case I am not able, you have the property, you can recover from it. So there is no transfer of possession of property to mortgagee. That is, there is no transfer of ownership or transfer of possession or transfer of title deeds. Mortgagee will only get a right to sell this property only if this person fails to return or repay the amount. Okay, so this is like based dependent on a contingent situation. Only if person fails to return or repay, in such a case only they can ask for they can use this property to recover this amount. Okay, that is simple mortgage under section 58B, where only a declaration is being made by the person that in case I fail, here is my specific immovable property. You can sell it and you can recover the amount from this property. Okay.
Okay.
Second one is mortgage by conditional sale. That is given under section 58C. Now, when we see this word, right, mortgage by conditional sale, that means here sale is there. Okay, there is a sale transaction taking place here. But what kind of sale is it? It is conditional sale. There will be one condition imposed on the sale. So in mortgage by conditional sale, mortgager, that means original owner of the property. Original owner of the property or mortgager will first sell the property. Whatever specific immovable property he is having, he will sell the property to the other person in favor of mortgagee. From whom he is taking money, he will first sell this property to another person with a condition to revert it back to him if mortgager repays his loan with interest. If I am able to pay this entire amount, repay this entire amount plus the interest, in such a case, this property will revert to this person, to the mortgager, the owner of the property. And if he fails to do, then mortgagee will become absolute owner. When we say absolute owner, who is an absolute owner?
Who has the right to alienation and enjoyment of the property?
Yes, when you get all the rights, alienation, enjoyment, like all the rights you are basically getting here. In jurisprudence, you will get one concept, ownership and possession. So possession is like 9 out of 10 points of law. That means in case of possession, you have almost everything. Just that you are not the owner. Okay, just that one right you are not having. But in case of ownership, you have everything. You can enjoy the property to the exclusion of this entire world. So here also this person was initially not an absolute owner. Just for the namesake, property was transferred to him. Okay, there was a sale transaction taking place, but then it was conditional sale. A condition was there that in case mortgager is able to return the amount plus the interest completely, property will revert to him. Only if he fails within the duration, then only mortgagee will become an absolute owner. So initially when this transaction happened, mortgagee was not an absolute owner. For the namesake only he was an owner. But later on, if this condition is satisfied, that mortgager is not able to repay, then only he will become an absolute owner of the property.
Ma'am, if that in that case, when the mortgagor fails to pay the amount, then can this be considered as a transfer deed? Or you have to register the transfer again?
Which one?
Like in case this loan is defaulted and it is the person mortgagee gets the property, will it be considered as a transfer then?
Yeah, we have these differences also. Okay, we will discuss that. Actually, there are two different types where the sale is taking place. So we will discuss the differences. There I'll tell you what is the situation. Okay. Yeah. So here also there is sale taking place, but it is conditional sale. Condition is being imposed. In this kind of mortgage, the transaction appears like a sale. If we look from outside, yes, it is conditional sale. What if a condition is that it still is a sale? But in reality, it's not like a sale because it is coming with one condition. And until this point, right, until this person is having this time to repay the amount, until then, the sale is not yet completed. That's why we are saying person can eventually become like the absolute owner. For now, he is not an absolute owner. So even though it appears like a sale, it's not a sale as such because it will be complete transaction only when this person is not able to repay the amount. Okay, but in case he is able to repay, this transaction will become void because this condition was not being satisfied. Right? In contract also we get this provision that some conditions might be imposed. Contingent contract. If condition is satisfied, only then we can ask the other person to execute it. If condition is
But,
not being satisfied, we don't have an option. Yeah.
ma'am, is condition contract valid?
Yeah, condition, you can put conditions, but when can you ask for performance? You can ask for it only when the condition is being satisfied. Okay, and that condition has to be something that can be done. Okay, it should not be some like impossible act or something. Okay, what conditions can be imposed? There also we have some rules and conditions. If you are satisfying those, you can put conditions. That is completely valid. Okay, so contingent contract, you can read also, I think section 30 and section 31, contingent and wagering contract. So wagering is in most of the states in India, it's not valid except for few. But in case of contingent contract, you can do it if the condition is valid. But you can ask for its performance only when the condition is being satisfied. So same thing applies here. If person is able to repay the amount, that means your condition was not satisfied. So this transaction will become void. Then you cannot say that, okay, what if this person paid? I still want the property. That would not happen. Now, when you are entering into this kind of a mortgage, right? Mortgage by conditional sale, there one same document, okay? One same document will have to mention that there is this sale and only then the transaction. So transfer of property act must be in the same document. Whatever the condition is, right? That if this person is not able to return this amount within the duration mentioned, then property will come back to me. That's in same document. Condition also has to be mentioned. It should not be two different documents where there is one absolute sale taking place and in another case it's like they are putting a condition. Because if you are referring this single document, it appears like a sale. So it has to be in one single document. They are mentioning the condition also, that for now it's as if like I'm selling it to the person, but then this condition is imposed. If I'm able to repay the loan amount plus interest on time, this transaction will be cancelled out. Property will again come back to me. So that thing will be mentioned in the same document. You can even go through this case. It's like too many people are involved, too many this transaction, that transaction. But yes, if you have time, right, you can go through it. It's a big detailed facts and everything is there, but still you can refer it. All right, what happens? Yeah.
What is PRLRS, legal representatives?
Yeah, through legal representative. So this person died basically during this transaction and everything. Later on, his legal representatives filed this case, and it was actually an appeal before Supreme Court of India. So this person was alive when in lower court case was filed, then in high court case was filed, then in Supreme Court. So by that time he died. So legal representatives were not happy with the order. They filed the case.
Ma'am, my family law is the same. Like the appellant died during the appeal process. Then the scope of her daughter to pursue that appeal was taken. And how is this appeal considered? Like before considering the merit of the case, whether the court consider the is that qualified to be considered as an appeal or something?
For
Taking
appeal,
up the application.
Yeah, for appeal, actually, we have one provision like otherwise also we have some rules and regulations, right? If you are studying any specific law, it will say that for if the matter is of this much value, like if it's a very small amount, you should not be going for appeal. Okay, like if you are studying maybe Motor Vehicles Act, there also they will say if the amount of compensation is like very less, you should not be going, like some amount is also fixed over there, you should not be going for an appeal. I think some 2,500 or something, I forgot the amount, but yeah, some amount will be mentioned. Mostly if amount is below this much, you should not be going for appeal, just pay the amount and deal with it. Okay, that same thing is mentioned in most of the legislations, you will see. Plus there will be certain situations where maybe you approach the high court decided the case. At that point itself, there is some certificate given. Okay, certification of matters, you would get this provision in constitution where jurisdiction of high court, right? There you will get some article. Like High Court would basically certify that yes, we do feel that this matter is having some important questions of law, or might be some important questions of fact, and if parties are willing, either of the parties can approach before Supreme Court, and in opinion of High Court, if Supreme Court is taking up this matter, Supreme Court would not be wasting their time. Like it's of that importance. So they would usually certify it. If it is certified, you can directly go to the Supreme Court, file an appeal. If it's not certified, then also you have an option. Okay, it's not like you don't have any option. There is a concept called special leave. Yeah, SLA, right? Special leave for appeal. You can file that.
Yes, ma'am. Whether there'll be a hearing on the grounds, should the court consider the appeal?
Yeah, SLA will be on that ground only. If they accept your SLA, you will be able to, like, it will be considered like a regular appeal only. But if Supreme Court, that judge feels that no, this is not having any importance, they can reject your special leave for appeal also.
Ma'am, what about in High Court? If there is a appeal against the district court and it's happening in High Court, will there be a hearing on to consider the appeal?
For High Court, I'm not quite sure. I'm not quite sure whether district court would pass something or not. But yeah, there are these grounds mentioned, like I said, right? Amount, depending on punishment, imprisonment, what is the punishment being given? Is it something that lowest court said something, then the sessions court completely altered it? In those cases, for sure, High Court would attend those matters. Like that, like it depends on the specific legislation also. When you are studying these legislations, right, there you will get clear provision that for this certain matter, person should not be going for an appeal. If this is the case, person can go for appeal. So it depends on those like case to case basis whether you will be able to go or not. But I don't think like from district court there is no as such certification process, but usually in the judgment itself they would mention, right, that within these many days parties can go against this order also if they are not satisfied with it. So it depends on those specific provisions under which you had filed the case. If it was from some maybe Motor Vehicles Act or something, then you need to look at that specific legislation. From MACT, Motor Vehicle Claims Tribunal, if compensation amount is this much, they clearly mention that no, you should not be going for an appeal. Otherwise, yes, you can go for an appeal. So it depends on that specific legislation or the rules applicable in different tribunals which we have.
Okay.
Okay. Yeah. And if it is fulfilling those grounds or criteria, then yeah, the court would like entertain the matter, because that is again given in some law, right? So they would entertain the matter. So this is mortgage by conditional sale. Next one is usufructuary mortgage. So it basically is, usufruct basically is like making use of something, taking advantage or something. All right. So here what we are doing is we are getting a right to use or take advantage of somebody else's property. So here what happens, mortgager or owner of property will deliver possession of mortgaged property, and mortgagee is entitled to receive rents, profits, or whatever other benefits he is getting out of it, whether completely or parts of it, and try to settle this amount. Okay, whatever amount he had given plus interest, everything he would try to settle. And there he needs to maintain proper accounts of it also. Okay, so if the person is like, okay, fine, I have this plot of land where there are too many houses on rent, I cannot pay you the amount. So what you can do is, for the time being, you can take rents. Okay, these amounts you can collect from there, or some other benefit or advantage you can take. Once you have exhausted this, right, this much of principal sum plus interest is clear, then you need to return it to me. Okay, so basically your person is using the property or taking some advantage or taking some profits or benefits like rents and profits, and trying to settle the amount, principal sum plus the interest. He is trying to clear it. Once it's cleared, property will be returned to the person. So mortgager or the original owner of property will authorize the mortgagee that you can return possession until payment of mortgage money, until and unless you have the entire, you have received this entire amount, you can retain it. Such transaction is called usufructuary mortgage, and the mortgagee is usufructuary mortgagee. For example, giving fishery rights. A person might be having a fishery and he can say, I don't have money to pay you. So what you can do is, for an year or something, you can get fishery rights over here, right? I am transferring you fishery rights, or maybe you will be able to enjoy the benefits of this fishery. There, what person is doing that until and unless amount is clear, you make use of it, you take the advantage, you take the profits, rents, whatever. Okay, is this part clear?
Yes, ma'am.
3 different types, 3 more we have. Yes. Next one is English mortgage. So in English mortgage, mortgager transfers property absolutely to the mortgagee. And this one, what I was saying, right, is similar to conditional sale. In case of English mortgage, what is happening is absolutely property is transferred to the mortgagee, but there is only a promise or a proviso will be there. Okay, promises to pay the mortgage amount on a certain fixed date, and on payment of such amount, the mortgaged property should be retransferred to the mortgager as agreed. That means here it's not like conditional sale or something. It's complete sale only, because property is absolutely transferred to mortgagee. But here what we saw, property was initially for the namesake transferred, but transaction will be completed or person will be considered absolute owner only in case of default. But here initially itself, it is absolute transfer of the property. So first of all, property is absolutely transferred to the mortgagee, but there will be one proviso there. Okay, what is the proviso? That in case I am able to return the amount plus the interest within the specified duration, in that case, what happens is this property will be retransferred to me. Okay, this property will be retransferred to the original owner, and that is the agreement here. That means it's not it depends on this thing only, right? That it's initially itself, it's absolute, but here initially there is a condition. Later on only it can become, or it may not become, an absolute transaction.
Ma'am, is there any significance for the name English mortgage?
I think it's derived from mostly in transfer of property principles are derived from English common law or their provisions only, right? Might be it was popular at that time. Might be the reason. Okay, but yeah. So initially they will just initially itself there will be this proviso there, and then the transaction will be from starting itself, it will be considered as an absolute transaction, where the mortgager binds himself to repay the mortgage amount on a certain date and transfers the mortgage property absolutely, but subject to a proviso that it will be retransferred upon payment of mortgage money. It will be considered as English mortgage. And we will see the differences as well between English mortgage and mortgage by conditional sale. So basic thing is that here it's absolute from the starting itself. Next one is mortgage by deposit of title deeds or equitable mortgage. So here title deeds or property related documents are being submitted to the person, and that itself creates like a security. So if property documents are given to the mortgagee, definitely mortgager cannot sell it, cannot do anything with the property because he is not having the property documents itself. So that is what is mortgage by deposit of title deeds. It is also considered as equitable mortgage. And that is most common type of mortgage also, where property documents are given. Otherwise, a person property might be on mortgage and he can again sell the property or do something. So those situations will not take place there. So those were 5 different types of mortgage which we saw, where depending on how mortgage deed was made, what conditions were put, we have those classifications. Apart from those also, right, like in case of contract, what we see, Contract Act as such is not telling us that this is a condition which you should put, this is a condition that you cannot put, right? It's not telling us what we need to write in the contract. We are free to write whatever we want. It's just giving us some guiding principles, right? That the clauses or terms should not be this way, it has to be that way. Like that is just giving us some guiding principles. And these transactions, like different modes of alienation of property, whatever deed is entered between parties, it's also somewhat similar to a contract itself, right? That one person is giving an amount, another person is making a promise that yes, I'll return it, I'll return with interest and stuff. It's also like a contract only. And there can be again different ways or different clauses inserted by persons, right? So that is why we have one more additional provision, that is anomalous mortgage. So what is anomalous mortgage? If there is a mortgage which is not falling under any of these 5 different types, okay, within the meaning of this section, then we will say that it falls under this last type, anomalous mortgage. In such a mortgage, the possession may or may not be delivered. Mortgages right is by sale or also foreclosure. If the terms, whatever they want, basically they can do it. Okay, it's not restricted as such like these other different types which we have seen, but parties are also free that whatever you want to make provisions, right? Whatever terms or clauses you want to insert, you can do that. That is the last type which we have, anomalous mortgage. Okay, and this is like in short, just so that you don't get confused, you can read from here. What is simple mortgage? Simply, person will make a declaration. Yeah, there is no delivery of possession. What is conditional sale?
When the loan is defaulted, it becomes the mortgagee becomes the absolute owner of the property.
Yeah. Next one.
Usufructuary mortgage. In the meantime, in the stipulated time, the mortgagee will be able to benefit from the property.
Yeah, take benefits from the property, right? Next one.
English mortgage, from the initiation itself, it's a transfer of property which can be reverted back at the fulfillment of the loan amount.
Yeah.
And mortgage by deposit of title deeds is title deeds of a property is pledged with a person and loan amount is acquired.
Yeah.
And any particular mortgage that doesn't belong to the first 3 types of mortgage will fall under 6.
Yeah, right. So these are 6 different types, and all of these are defined under section 58 itself. And if you remember them in this sequence, you will be able to remember the subclauses also. That 58A provides for definition, and after that B, C, D, E, F, accordingly, it has all these different types. Now, differences between mortgage by conditional sale and English mortgage, because in both the two situations, it's sort of, there is a transaction already, property is being transferred, ownership is being transferred. So what are the differences? Mortgage by conditional sale. In mortgage by conditional sale, the existence of debt between seller and buyer is necessary. This debt is already existing, right? Because whatever transaction it is, that transaction is not yet completed. That means the person, mortgager, is still under the debt, that he needs to return the amount, he needs to repay it. It's not like this transaction is already done and over between the parties. He is still under an obligation to repay the loan. In case he fails, then only this transaction will become completed. Okay, so in case of mortgage by conditional sale, existence of debt is there. It's not already settled between parties. Just the provision is mentioned that how it will be settled at a later stage. if the mortgagor is not able to return or repay the amount. But in case of English mortgage, there is no existing debt as such, because amount was given and already complete sale was also there, right? Completely property was transferred. Yes, there is a proviso, and that's how it is not like a proper sale as we discussed under chapter 3 of the transfer of property act. Just because of that proviso, it is different, but otherwise, there is no existing debt as such, already it's settled. You gave money, this person gave property. Yeah.
Ma'am, there will be a time specified in this English mortgage, right?
Yeah.
So it's like a transfer with an absolute alienation for a speculated time, a specific time, right? Like the transferee cannot sell that property to anyone else in that time, right? Even though he is enjoying the absolute ownership of that land.
Yes, yes, because he needs to wait for that given duration just because of that.
Okay.
Yeah.
So if there is a question regarding if is there an exception to absolute transfer of property, can we cite this? Like absolute alienation, section 12.
It is actually like mortgage, right? It's the purpose is not selling the property as such, right? It's mortgage again. I don't think that would be a good example to mention in this conditions restraining alienation. There are other better examples that we have.
Okay, ma'am. Like there is no absolute alienation is not acceptable, right?
Yeah.
But here the absolute alienation, even though he's the absolute owner, he has an absolute alienation imposed upon him. The English mortgage.
Not like absolute alienation again. It will be for one limited duration only, right? 1 year, 2 years, like that.
Okay.
Okay, absolute alienation, as in if you are saying like we have some examples, those you can mention actually, better examples, I feel. Okay. Because otherwise, if you are not putting that condition, this mortgage itself would be difficult, right? So these conditions we need. Yeah. So next one is in mortgage by conditional sale, only some interest in the property is transferred to the mortgagee. It's like for the time being, it's there is just the possibility that person will be getting it, okay, in a future date. So it is not yet like completed. But in case of English mortgage, all the interest to the property is being transferred except personal right to repurchase. Just this thing is there, like you said, that he needs to wait for that duration. So that is just the only condition, that the mortgagor is having a right to repurchase it, and same way mortgagee needs to wait for that duration. Apart from that, every other thing he will be having, every other right the person will be getting. In case of mortgage by conditional sale, sale transaction is not final initially, but it is contingent on a future event. We need to see if that situation will happen or not, if that contingent condition will be fulfilled or not. If it happens, transaction will become absolute. If person is able to repay the amount, then this transaction will be considered as void. So in future only we will come to know what will happen with it. But in case of English mortgage, sale transaction is absolute from the very beginning itself, just that there is a proviso and accordingly person will have to wait for a certain duration. Mortgage by conditional sale may not have stamp duty registration cost implications, because they might only on papers agree that, okay, fine, if I'm not able to repay, then this transaction would be completed. After that also they can get the transfer, registration and stuff done. But in English mortgage, because it's already an absolute transfer, property will also be transferred in name of the mortgagee. Stamp duty registration charges also will be there. So considering that English mortgage is expensive, Okay, because there everything is already done, and then again same thing unnecessarily will again be done to the other person.
Ma'am, is there any is this English mortgage done for a long duration of time? Like there should be some benefit in opting English mortgage, right? A rationale behind it. So there are leases for 50 or 60 years. So is the English mortgage on the same line?
English mortgage is not that common actually because of the expenses that are there, right? It is not that common because unnecessarily party will have to pay for the registration and everything, and later again same thing will be done by the other person also. It's like unnecessary waste only, right, for them. But if this case you consider, their condition is there, if it happens or does not happen at that stage you can do it. It's not that common, English mortgage. Deposit by title, that is very common. Then your declaration also is somewhat common, but deposit of title is most commonly followed. Okay. Even when person is taking loan to buy a property or something, there also they would deposit the property documents to the bank, right? So that they cannot sell it or do anything. They need to completely repay the amount. After that only the original documents would be given to them. So in mortgage by conditional sale, the mortgager sells the property to the lender with an inbuilt condition making the sale to be void in case he is able to pay. So in the agreement itself, it's like an inbuilt condition mentioned in the agreement itself that in case I'm able to repay the amount plus the interest, this transaction will become void. This transaction will not be applicable there. But in case of English mortgage, mortgager transfers immovable property to mortgagee, and mortgagee will transfer it back on a future date if the mortgager is able to pay the entire amount plus the interest. Then there is just this proviso that we have that he will have to repay or return this amount. Okay, was this part clear?
Okay, ma'am. Yeah.